The Manusmriti, also known as the Dharma Shastra, is one of the most significant ancient legal and social texts in India, traditionally attributed to the sage Manu. Composed approximately between 200 BCE and 200 CE, it represents an early codification of laws, ethics, and social norms in the Indian subcontinent. Although often considered a religious text, its legal dimensions had far-reaching implications for governance, social hierarchy, and justice in ancient India. The Manusmriti provides valuable insight into how early Indian society conceptualized justice, duty, dharma, and social order, intertwining moral, religious, and legal imperatives. Historical context. The Manusmriti emerged during a period when India was undergoing significant socio-political changes, with the consolidation of kingdoms, the expansion of trade, and the evolution of Brahmanical authority. It is part of a broader corpus of texts called the Dharma Shastras, which are essentially treatises on Dharma, encompassing duties, rights, laws, conduct, and justice. Unlike modern legal codes, the Manusmriti was normative and prescriptive rather than descriptive, intended as a guide for rulers, priests, and common people on how to live a morally and socially proper life. It reflects a society structured by varna, class, and ashrama, stages of life, emphasizing that justice was inseparable from social hierarchy and religious morality. Concept of justice in Manusmriti. In the Manusmriti, justice is closely tied to the idea of dharma. Dharma encompasses moral law, social duties, and cosmic order. Justice is not merely punitive, but restorative and corrective, aimed at maintaining social harmony. Several principles underpin justice according to Manusmriti. 1. Varna and social hierarchy. The Manusmriti categorizes individuals into 4 varnas: Brahmins, Kshatriyas, Vaishyas, and Shudras. The application of justice varied according to varna. Punishments, fines, and legal rights were not equal for all. For instance, a crime committed by a Brahmin was treated differently than the same crime by a Shudra. While modern readers may find this discriminatory, it reflected the ancient perception of social order as essential for stability. 2. Proportional punishment. Punishments were ideally proportionate to the nature of the offense and the social status of the offender and the victim. Compensation, fines, and penances were prescribed as remedies for offenses, emphasizing restitution and balance rather than retribution alone. 3. Role of king in courts. The king, Raja, was the ultimate authority responsible for ensuring justice, guided by learned Brahmins and ministers. The Manusmriti emphasizes that rulers must act without bias, uphold dharma, and protect the weak, suggesting an early recognition of state responsibility in justice administration. 4. Restorative and corrective justice. The text often prescribes penances, expiations, or fines instead of severe corporal punishment, particularly for non-violent offenses. The aim was to restore moral order and reintegrate the offender into society, reflecting a restorative conception of justice rather than purely punitive law. 5. Moral and religious dimensions. Justice in Manusmriti is inseparable from moral and spiritual life. Acts of injustice were considered offenses against the cosmic order, Rita, or Dharma, not only against individuals. This link between law and morality meant that rulers and citizens were expected to act ethically, with divine accountability serving as an enforcement mechanism. Administration of justice. The Manusmriti prescribes detailed procedures for legal administration. Judicial authority. The king, aided by ministers and learned Brahmins, served as the final adjudicator. Local assemblies and community elders also played a role in dispute resolution, indicating a decentralized yet hierarchical system. Evidence and witnesses. Evidence, oaths, and witnesses were critical for determining guilt. The text emphasizes truthfulness and the importance of verifying facts, revealing an early concern for procedural fairness. Punishments and penalties. Offenses were categorized, and punishments ranged from fines and restitution to corporal punishment, depending on the social status of the parties involved. For instance, theft or adultery committed by a Kshatriya might result in exile or fines, whereas similar acts by a Shudra could be punished more severely. Women and justice. Women were considered legally dependent, with their rights often mediated through male guardians. The Manusmriti prescribes specific penalties for offenses against women, reflecting both protective intent and patriarchal limitations. Influence on Indian legal history. The influence of Manusmriti on Indian law and justice extends into the medieval period and even colonial administration. 1. Medieval India. Hindu kings and regional rulers often consulted Brahmin scholars for legal guidance based on Dharma Shastra principles. While local customs and regional variations existed, the Manusmriti provided a normative reference for defining crimes, punishments, and social obligations. British colonial period. During the British East India Company's rule, Manusmriti was instrumental in codifying Hindu personal law. British administrators relied on it to adjudicate issues of marriage, inheritance, and caste-based regulations. However, they often misinterpreted or selectively applied its principles, sometimes emphasizing rigid caste hierarchies over customary practices. 3. Modern Indian law. In independent India, the Constitution of 1950 replaced Dharmashastra-based legal norms with secular, egalitarian legislation. Nevertheless, the Manusmriti continues to influence discussions on morality, social justice, and caste in contemporary India, often serving as a historical benchmark in debates over law, religion, and social reform. Criticism and controversy. The Manusmriti has faced criticism for codifying social inequality, particularly the rigid caste system and gender hierarchies. Reformers like B.R. Ambedkar condemned it for perpetuating social discrimination, arguing that it entrenched Brahminical dominance and suppressed marginalized communities. Women's rights scholars also critique its restrictive approach to female autonomy. Despite this, scholars recognize its historical and cultural significance as a window into ancient Indian thought on justice and governance. Legacy and philosophical significance. The Manusmriti embodies a vision of justice that intertwines morality, religion, and social order. While modern notions of equality, secularism, and human rights diverge sharply from its prescriptions, it remains a cornerstone for understanding how early Indian society conceptualized law. Its emphasis on dharma, ethical governance, and the king's responsibility resonates with contemporary discussions on restorative justice and moral leadership. Scholars continue to study it not as a guide for legal practice today, but as a reflection of the moral legal imagination of ancient India. Conclusion. The Manusmriti represents a foundational legal text in India that shaped concepts of justice, governance, and social order. Its prescriptions reflect a society where law, morality, and religion were inseparably linked, and where justice was conceived as maintaining harmony and dharma, rather than enforcing abstract equality. While it institutionalized social hierarchies that are incompatible with modern principles of justice, it provides invaluable insight into ancient Indian legal thought. Its influence persisted across centuries, affecting medieval jurisprudence and colonial administration, and continues to inform scholarly debates on law, ethics, and social reform in India. Sources 1. Olivelle P. 2005, Manu's Code of Law, a critical edition and translation of the Manava Dharmasastra, Oxford University Press. 2. Doniger W. and Smith B. K. 1991, The Laws of Manu, Penguin Classics. 3. Derrett J. D. M. 1968, Religion, Law, and the State in India, Faber and Faber. 4. Olivelle P. 1999, The Dharmasastra, Introduction, Translation, and Notes, Oxford University Press. 5. B.R. Ambedkar, 1945, Annihilation of Caste. 6. Kane P.V. 1968, History of Dharmasastra, Ancient and Medieval Religious and Civil Law in India, Bhandarkar Oriental Research Institute.